is a statement that, they have to be looking,
That's all right. Didn't they say that they think that it was possible that she's the one?
Yeah.
Isn't that what she said?
Yes.
All right. What is that? How does that fit into your argument or not into your argument? What is that?
That is basically, they're looking for her saying either, yes, yes, I did it, or no, I didn't do it. Or, so that is a statement that they believe, that's the sort of statement that they make it, and they believe that they have a likely response of her either saying, yes, I did do it, or no, I didn't do it. And yes, I did do it would be an incriminating response.
Why isn't that just a normal booking question?
Because it fits in with it's basically it's asking her if she did it, which would be eliciting incriminating response.
Continue.
And if you compare Adrienne Vega's questioning with Tony DeLuca's questioning, Tony DeLuca's questioning was about 20 minutes. Adrienne Vega's questioning was near 50 minutes.
So am I to look at the various individuals when they're questioned in cases and compare lengths of time and where they are to determine totality of the circumstances to your client?
Well, it helps determine if she's in interrogation, because if you look at it just very flatly, they're both suspects. They both have an equal, as far as they know at this point, they have an equal chance of being the one who's driving the car. So
when you say they're both suspects, why do you say that?
Because they are the two people that could be driving the Bueller.
Okay. Assuming for the moment that I'm to get into the officer's state of mind, which I'm not agreeing I'm to do,
Okay.
but let's just make that assumption. At the point in time Officer Wright and Officer Jackson talked to DeLuca, what is the officer's state of mind?
I believe they were biased against her because they had...
Against DeLuca?
Or no, sorry, I thought you said Vega. No.
DeLuca.
At DeLuca, they are open-minded and they want to know what happened. They want to know what she thought happened. But she is home, so they do believe she could have been the one who was driving it because she was there. The Bueller was right there. But they are less biased against her than they will be against Adrienne later because they hadn't heard anything yet about Tony being the one driving.
So would your argument be the same if the police talked to your client first?
My client's interrogation would have been different if my police had talked to my client.
Why do you think it would have been different?
Because Tony's was different.
Well, what would your client say that would have been different?
My client would have said anything different, but the police would have not. The police most likely wouldn't have asked her question multiple times. The police would have not badgered her with questions about asking her the same question multiple times, which would have been different. They would have asked her a single time, like Tony said, making it not an interrogation.
All right, continue.
That is all I have to say.
Well, okay, hold on.
Or do you have more questions?
Oh, geez, do I?
Okay.
I don't think there's a time when I don't have questions. All right, so I asked you at the beginning about Miranda. Remember that?
Yes.
I asked you what the situation of Mr. Miranda was, and you told me he's at a police station, he's being interrogated.
Yeah.
What is the concept that Chief Justice Warren wrote in Miranda? What was the Chief Justice trying to convey when he wrote that opinion and came down with Miranda? What is it? What's the law he gave us?
That someone must be informed of their Fifth Amendment rights when they are in custody.
Why?
Because they have the right to know them. It's part of their constitutional rights, and not informing them would inhibit their constitutional rights.
And that constitutional right would be what?
The Fifth Amendment right not to play witness against yourself and not to incriminate yourself.
And that's the Fifth Amendment, which is out of what Constitution?
Our Constitution.
Our being what?
The United States Constitution.
And I'm here in, I believe, San Mateo County as a visiting judge. So why should I be concerned about the U.S. Constitution when I'm in San Mateo County in the state of California?
The state of California is part of the United States of America.
Okay. Doesn't California have its own constitution?
Yes, the United States Constitution is the overarching law of the land that all must follow.
Okay, and if that's true, can you tell me why it would apply to San Mateo County?
It applies to San Mateo County because we are citizens of the United States of America, and we are given those rights that in the Fifth Amendment.
Okay. You haven't said anything about the case of Mathiasen. Why is that? Do you think that case does not help you?
No, I didn't think it was.
Why?
Because the cases outlined in Mathiasen, the holdings, the fact situation do not lean towards supporting my client.
What's the fact situation with Mathiasen?
Mathiasen, I'm sorry, I cannot remember.
Okay, isn't Mathiasen the case where the officers go to a house, knock on the door, nobody's there, leave a card, does this card say, gee whiz, when you get home, call us? And Mr. Mathiasen gets home and he sees the card and he says, oh, I'll give you a call. And they say, hey, come on down, you, come on down. And Mathiasen says, sure, I'll come on down. And then Mathiasen comes on down to the police department and they put him in a room, very big room, and shut the door. And what's the court say? Is Mr. Mathiasen in custody or not in custody?
Mr. Mathiasen is not in custody.
And why is that? What did the court say?
Because he came up his own free will.
Okay. Why didn't your client, why shouldn't I say that your client used her own free will to get into her car? Or to get onto her property? Or to approach the officers? Well, nobody held a gun to her head.
But no one held a gun to her head, but there are threats other than the literal threat of holding a gun to her head. She saw the police and she might have been worried, and so she came up to the police officers. She's from a political family. She feels the need to go to the police. She's been taught all her life to respect the police and to do what they say, and she doesn't want to hurt her mom's reputation or anything. So if she sees the police officer, she's gonna go up and she's gonna figure out what's wrong, and she's gonna do her best to help them.
Okay, well, didn't she just voluntarily go up to the police and voluntarily go with what they asked and voluntarily answer all the questions and voluntarily get into the police car and voluntarily sit there?
She was not voluntarily answering all their questions. She never was told she could leave, and she was basically, as I said before, she was basically told that she could either answer their questions here or answer their questions there. There was no option of not answering questions or calling your parents and talking to them and then answering our questions.
Is there a case that you have that talks about not answering questions or answering questions should not be looked at as either good or bad for your client?
Not that I can remember, sir.
Do you have anything else?
No.
Okay. All right, thank you, Ms. Bell. All right, Ms. Ham.
Yes, Your Honor.